I'll call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is February 16th, 2023. A quorum is present, so we will get started. First item on the agenda are the minutes, and we do have two sets of minutes to approve. First, may I have a motion to approve the minutes for February 9th, 2023? Anyone? Thank you, Representative Friedrich. Moves to approve approval of the minutes for February 9th, 2023. All those in favor?
Aye.
It's a little slow this morning. Any opposed? The minutes for February 9th are approved. Second, may I have a motion to approve the minutes for February 14th, 2023?
So moved.
Thank you. Representative Scott moves approval of the minutes for February 14th, 2023. All those in favor?
Aye.
There we go. All those opposed? The minutes for February 14th are approved. First item on the agenda, we will have a Judicial Branch overview and budget presentation. Mr. Schwarber, please proceed. Please introduce yourself for the record and proceed.
Good morning, Chair Frazier and members of the committee. My name is Jeff Schwarba, and I am the State Court Administrator for the Minnesota Judicial Branch. I'm pleased to be with you today to give you an update on Minnesota's third branch of government and to seek your support for our fiscal year 24-25 biennial budget. At the outset, I share our appreciation to Governor Walz for including the entirety of this important funding request in his biennial budget recommendations to the legislature. And we are hopeful that you and your colleagues in the Senate will be helped to prioritize funding for our courts and broader justice system in this next two-year budget. Chief Justice Gilday wanted me to relay the message that she looks forward to working with you during this session. If you've not already heard from her, we are scheduling meetings with all of you to chat with you about what's going on in the Judicial Branch. The Judicial Branch's mission is to provide justice through a system that assures equal access for the fair and timely resolution of cases and controversies. The importance of our work is reflected in Article 1, Section 8 of the Minnesota Constitution, which promises that every person in our state is entitled to access justice freely, promptly, and without delay. I know our judicial officers and staff take this promise very seriously as we do our work. The Minnesota Judicial Branch comprises the three levels of state court in Minnesota: the Supreme Court, the Court of Appeals, and the district courts. Our 322 judges and 2,500 staff work in 103 different locations across the state, more than any part of state government. Each year, roughly 1 million cases are filed in our district courts. It was a little higher than 1 million during the pre-pandemic times, and it's been a little lower during the pandemic. Our courts are funded almost entirely through legislative appropriation. All of the revenue we collect through court fines and fees is deposited in the state's general fund or to local government or other statutorily mandated programs. We don't retain any of that revenue. We depend on your appropriation to fund the vital work of our judiciary. Our current biennial budget for fiscal year 22-23 is approximately $768 million. That's equal to roughly 1.5% of the state general fund budget. Speaking of our budget, I'll now turn our attention to our biennial budget request. The Minnesota Judicial Branch is proud to have maintained an open door to justice throughout the COVID-19 pandemic. By leveraging remote court hearings and nation-leading safety protocols, the Judicial Branch has ensured Minnesotans have always had a place to turn to seek justice, protect their rights, and peacefully resolve their disputes. As Minnesotans emerge from this time of crisis, the Judicial Branch is using the lessons and experiences of the pandemic to modernize and improve how the judiciary serves the people of Minnesota. We now need the legislature's help to ensure that our courts can continue to deliver timely and effective access to justice, eliminate a lingering criminal case backlog stemming from the pandemic, and expand access to justice through remote hearings and other technological innovations. The single biggest challenge facing the Minnesota Judicial Branch is retaining and attracting a skilled workforce. To be clear, we recognize that the Judicial Branch is far from the only employer facing issues with employee recruitment and retention. However, the judicial branch compensation structure has fallen significantly behind other public sector employers in Minnesota, which is adding to our workforce challenges. For those of you who served on the committee last year, you'll recall that I shared similar concerns about our uncompetitive compensation structure in 2022. Our challenges since then have only grown worse, as the lack of an omnibus public safety bill last year meant our judicial officers and staff did not receive a salary increase in fiscal year 23. In fiscal year 22, we conducted a salary analysis comparing judicial branch salaries to public sector peers. From that analysis, we learned that the average wages for many judicial branch positions were 5 to 10% below wages for similar jobs in the public sector. We also know that many of our public sector peers provided salary increases of 5 to 7% in fiscal year 23, which means we have already fallen further behind from our 22 analysis. To give you a clear picture of what this looks like to our employees, here on the screen is a hypothetical salary progression of 2 employees hired at the same time. At the top is an employee hired in the executive branch of state government, and on the bottom, the judicial branch. While the 2 employees were hired at the same rate of pay, in just 4 years, the judicial branch employee is earning 12% less than the executive branch counterpart. That's a difference of about $5,500 per year in lower earnings. These next 2 slides highlight the challenges we are facing in employee recruitment and retention as a result of our uncompetitive compensation structure. Between 2018 and 2022, we have seen the share of employees leaving the judicial branch each year nearly double. In exit surveys, departing employees give the #1 reason for leaving: salary. Meanwhile, the number of applicants for each open position with our courts has fallen dramatically. In 2019, we were receiving nearly 50 applicants for every vacancy. Today, we're only receiving an average of 13 applicants for each position. Those numbers are even lower in more technical and skilled positions such as IT, where we have had several open positions receive 0 applications. I recently asked our judicial district administrators to describe the challenges they are facing in employee recruitment and retention, and here on the screen are just a handful of quotes taken from the pages and pages of feedback I received. One of the clear themes from these messages is that courts are seeing judges and staff leaving the judicial branch to accept higher paying opportunities in city and county government and other parts of state government. And applicants are turning down positions because they are finding significantly higher pay with other employers. High turnover and extended vacancies are having a very real impact on how our courts serve the people of Minnesota. Our court administrators are being forced to postpone or delay scheduling of court hearings because of staffing shortages. Some are even considering closing some of their customer service windows. Because so much of our work right now is focused on addressing our criminal case backlog, our workforce issues are creating delays in other areas. Courts are reporting significant delays in housing court, family law cases, and other important matters. One court clerk recently reported that she was 6 weeks behind in entering marriage dissolutions into the case record. That means couples are waiting a month and a half after their final hearing to have their divorce officially entered into the case record. It's not hard to imagine the frustration and confusion that delay adds to an already difficult process. To put it simply, the workforce crisis in our courts is threatening our ability to provide access to justice for the people of Minnesota and jeopardizing the people's trust and confidence in our judiciary. To address these workforce challenges, the judicial branch is seeking funding to increase judge compensation by 9% in fiscal year 24 and 6% in fiscal year 25, and to provide a 9% compensation pool for employees in fiscal year 24 and 6% in fiscal year 25. In addition, as we always do with our biennial budget request, we are seeking funding for the employer share of health insurance premium increases in each year of the biennium. By making our compensation structure more competitive, the legislature can really help our courts continue to deliver timely access to justice and ensure that our courts can continue to recruit and retain the skilled and experienced workforce we need to drive innovation in our justice system and provide high-quality service to the people of Minnesota. Our next funding priority relates to one of the lingering impacts of the COVID-19 pandemic on our courts, a backlog of felony and gross misdemeanor cases in our district courts. As you can see on the screen, the number of felony and gross misdemeanor cases awaiting resolution in our district courts grew by nearly 40% between the start of the pandemic and late 2021. Most of that growth came from the first months of the pandemic when the governor's stay-at-home order was in place and there was very little in-person activity happening in our courthouses. In November 2021, we implemented a statewide strategy to eliminate this backlog of major criminal cases. That strategy has been supported by federal pandemic relief funding, which has allowed us to use senior judges and temporary staff to hear and resolve additional cases. The good news is that strategy is working. As of today, we have eliminated more than half, 54% of the major criminal case backlog. However, the federal pandemic relief funding that we have been relying on to achieve this success will soon expire, and we are now asking for the legislature's help in addressing the remainder of the pandemic backlog. Our request seeks $8.4 million in one-time funding in fiscal year 24 to allow us to continue our successful backlog reduction efforts. We will use this funding to continue using senior judges and temporary staff to help eliminate the remainder of the pandemic backlog during the upcoming biennium. We also asked the legislature to help us sustain what may be our greatest success of the pandemic, which is the use of remote or online court hearings. Prior to the pandemic, remote or online court hearings were fairly rare in Minnesota. But during the pandemic, online hearings played a vital role in ensuring access to justice, as more than 80% of all district court hearings were held in online courtrooms. While our transition to the large-scale use of remote hearings was born out of necessity, it quickly became clear that the people we serve found real value in this method of delivering justice. In surveys and focus groups, litigants told us that they preferred remote hearings because they reduce travel time and costs and are easier to attend without taking as much time off work or finding childcare. Attorneys and justice partners said that remote hearings worked better for many types of cases because they saved them time and money and led to more reliable scheduling and hearing start times. Civil legal aid said that remote hearings helped them more easily serve and represent clients all over the state. And victim advocate groups reported that victims feel safer and more empowered to participate in court hearings remotely. Given the success of remote hearings during the pandemic, the Minnesota Judicial Branch has made a long-term commitment to continue using remote hearings for many case types into the future. Early last year, the Minnesota Judicial Council adopted the One Court Minnesota Hearings Initiative policy, which sets out a statewide framework for how our courts use both in-person and remote hearings to deliver access to justice. That policy took effect on June 6th, and we continue to hear positive feedback from court users about the ease and convenience of online court hearings. We have also heard accolades from other states who truly view Minnesota as a leader in the digital transformation of court operations. To support the long-term use of remote hearings, we are seeking $7.4 million in one-time funding to help us modernize our court technology to help better support remote and hybrid court hearings. The funding will also allow us to upgrade court interpreter equipment and capabilities and implement other needed technology enhancements in our courts. To close my presentation, I'll quickly cover three smaller funding items that are part of our budget request. The first is addressing the rising cost of providing mandated psychological services. The Judicial Branch has experienced significant cost increases in this area. Over the past 3 years, the number of criminal psychological examinations ordered each year has increased by 28%, while the number of civil commitment examinations has grown by 48%. In total, the overall cost of providing these services grew by 58%. We're seeking $1.996 million in annual funding to offset the increased cost of providing these statutorily mandated services. Our next request relates to treatment courts, which is a term that encompasses programs such as drug courts, DWI courts, veteran courts, mental health courts, and similar programs. There are currently 4 treatment court programs across the state, which you can see here on the screen, that were established under federal grants that will soon expire. These valuable programs have proven to be successful, so we're seeking $422,000 in annual funding to add them to the state's treatment court funding formula, ensure they continue serving their communities. Our final part of our request relates to court interpreters. The 2021 legislature provided a one-time appropriation that allowed us to increase the hourly fees paid to contract court interpreters by 8%. But without permanent funding, those payment rates will soon expire. The Judicial Branch is seeking $200,000 in ongoing annual funding to permanently sustain that increase. In total, the Judicial Branch is seeking $87.7 million in new permanent funding in fiscal year 24-25, an 11.22% increase over our base annual budget, biennial budget. In addition, we are seeking $15.8 million in one-time funding to address the backlog and technology needs I discussed earlier. Members, I want to thank you on behalf of the Minnesota Judicial Branch for your time and attention and your consideration of this vital funding request for Minnesota's judiciary. We're extremely proud of the work we have done during the pandemic and all of the innovations we're facing and putting in place, but the challenges are very large in terms of our staff and judges, so we ask for your help. Chair, I need to go to a Judicial Council meeting, but I was asked to address a bill you're going to be taking up later, House File 305, which would eliminate fees for public documents. If the committee remembers, in March of 2021, we instituted what we call Minnesota Court Records Online, or MCRO, which was a new way to access public documents. It's been a resounding success. It was developed on time and on budget, and it's been very, very popular. But we decided at the time we developed it that we would wait on instituting the fee portion, which is required by statute, until we heard from the legislature. So we have not developed that component of the program. If the legislature decides not to charge for these fees, which, as I mentioned earlier, go to the general fund, we are very much in favor of that. It will save us time and money developing that last portion of MCRO, and I think will also improve access to justice for people who are looking for these documents all over the state. So thank you very much.
Thank you, Mr. Schwarber. We'll now go into committee discussion, and we do have a number of members on the list. First, Representative Moller.
Thank you, Mr. Chair, and it's nice to see you again, Mr. Shorba. Thanks for being here. I had a couple of questions. I guess I'll start on page 7 of the handout, and it was talking about executive branch versus judicial branch, the judicial branch falling behind the salaries. And I just want to clarify that that's for your court staff. A lot of these slides have to deal with staff versus judges. Is that right?
Sure.
Chair Fraser, Representative Moller, you are correct. Judge compensation is set by the legislature, so they set an actual salary for each level of court. So those slides are talking about staff. And in the judicial branch, because we're not that large and we're about 90% staff and salaries, we don't have a lot of flexibility to provide compensation unless the legislature provides it. So during the last biennium, we were fairly conservative because at that time we thought we had a deficit. So we only asked for funding for the first year, which we provided to our staff. And then in the second year, we came in later in the biennium to ask for that funding. And as you know, that bill did not pass. So we were not able to provide compensation. The executive branch continued to provide compensation. They continue to provide not only across the board increases, but step increases. We don't have money to do that without funding from the legislature. So that's what put us behind.
Representative Moller, follow up.
Yeah, thank you. And I will say, too, you should be commended for the great work you did during the pandemic, keeping our courts functioning and running, and I'm definitely understanding of the backlog issues that you're facing right now. But I just was curious about judges' salaries. I'm curious to know what judges' salaries are in relation to other public sector jobs, like county attorneys, and perhaps judges in other states. And then I'll ask the second part of that question is, have you thought about separating out the request for employees versus judicial increase in salaries for judges.
Mr. Schwarber.
Chair Fraser, Representative Moller. The National Center for State Courts, which is an umbrella group for state courts around the country, does an annual survey of where judges lie in terms of compensation. They just released their findings on January 1st of 2023. The Minnesota judges have fallen further behind. We are now no longer in the top half of states, which I think is problematic. Our trial court judges are now 26th. Our Court of Appeals judges are 25th, and our Supreme Court justices are also 26th. So we're not trying to be number one, but we are trying to at least stay in the top half of the country in terms of our judicial salaries. It varies by jurisdiction with regard to your first question. There are certainly counties where judges make less than even assistant county attorneys in terms of compensation, and that's only gotten worse as well as the counties have continued to increase salaries. So in larger counties like Hennepin and Dakota and others, there may be judges who are making less than, not the county attorney, but somebody under the county attorney, which creates other problems for recruitment of new people who want to be judges. So it's definitely a problematic situation for us. Thank you.
Representative Moller. Representative Finke.
Thank you, Chair Frazier, and for your presentation. And my question was largely in the position or in the question that was asked by Representative Moller, and that we have a graph here that's charting an employee making $20 an hour, but a quick Google search showed me that we're paying about $170,000 an hour for. Not an hour, $170,000 salary for judges. And I'm just curious, and I'm asking this like literally, I'm a new person here. I don't know the answer to this. Like, will raising judge salaries 9% help fill the problem that you're actually presenting in this document, which is a workforce shortage? I don't particularly have a reason to oppose judges making a little more money, but will that actually solve this problem, which is we don't have the workers in the judicial branch to do the work that's being asked? So I don't even mean that to be hostile. I'm asking literally, how does that help this problem?
Mr. Schwarber.
Chair Fraser, Representative Finke, I think they are two separate issues. The compensation for our staff will help us based on our salary surveys of the market, and we're only comparing to public sector employers. A 9% and a 6% increase will allow us to get into what we call the competitive corridor for our staff. Judge compensation is sort of measured in different ways. We're looking at how we recruit judges. We have had judges leaving to go for higher paying jobs recently. And we're also finding that it's problematic in terms of the pool we're getting. The number of applicants for judgeships has gone down. And also, we tend to get, not that that's bad, but we tend to get more public sector lawyers applying for judge jobs rather than people who are coming maybe from a law firm or a civil practice. And we'd like to have a rounded sort of group of people who are serving as our judges. So it's a recruitment issue, and we're also seeing more of a retention issue with judges as well. So I know they make a lot more than our staff. That's why we're asking for a separate number for our staff. But we do think it's an issue that we need to tackle with regard to our judgeships as well.
Representative Finke. Yeah. Thank you, Mr. Schwarber. I'm a little partial to public sector, folks, but I do appreciate the diversity on the bench. Representative Scott.
Thank you, Mr. Chair. Thanks for being here, Mr. Schwarber. I had a couple of questions. The backlog issue, it's really hard to tell from the graph, like what is the number of backlog cases right now, if you have an idea what that might be rounded?
Chair Frazier, Representative Scott.
Mr. Schwarber.
We have about 6,000 cases right now. We were well above 9,000 cases when we started, so we've brought that down. We have 51 counties that have reached their backlog goal, and the goal was to get to the point we were before the pandemic. We always have cases pending, but that was our goal. So 51 counties have now reached that goal. Our initial goal was June of 2023. We're hoping we'll get more counties by then, but we don't think we'll get them all, which is why we're asking for some temporary funding.
President Scott.
Thank you, Chair. Mr. Schwarber, so the remote hearings, it's been a huge success. And so what savings has the court experienced in terms of going remote? I'm assuming there would be some savings there.
Chair Fraser, Representative
Mr.
Scott.
Schwarber, sorry. Go ahead.
Actually, during this transition period, it's actually taking longer to do remote hearings because you need to move people in and out of these rooms and say, before you could have a public defender just come and go in the hallway and meet with their client. Now somebody on our staff or the judge or the law clerk, whoever is assigned that task, now has to put those two in a Zoom room, make sure somebody else is ready for court hearing. So we're hoping, we're learning from how that's working as to how we can be more efficient with that. But I mean, we don't pay people to drive to work, so we're not saving any money there. We have had to invest in technology to be able to Zoom licenses and other kinds of things. So right now in the transition period, it's actually costing us a little more money to do it. But we're hoping with some of this one-time investment, we can figure out ways to do things a little more efficiently with the right technology. But it's a learning curve.
Representative Scott, any follow-up?
Thank you, Chair, and thank you for that answer, Mr. Shorba. I have the court's budget here, and I do have a question under the mandated psychological services issue. And the notes on page 14 of the budget say, in addition, on July 1st, 2022, the Judicial Branch assumed the cost of providing competency examinations previously funded by the Department of Human Services. And I'm just wondering the why behind that.
Mr. Schwarber?
That was,
Or do you need it?
Chair Fraser and Representative Scott, that was, I believe, a statutory change that we were required to do that. And in the time that the statute was changed, DHS never figured out that we were really supposed to be doing them. So then we were notified by DHS that under the statute, those were our requirements. So we assumed those costs. We probably should have been assuming those costs earlier based on what the statute said, but DHS had continued paying those costs and we weren't aware of the statutory change. So once we were notified, we had to take on those costs because of the statute. So it was already in law. It was just an assumption because we were notified by DHS. Those were now our responsibility. I hope that explains what.
Right. Thank you.
Representative Scott?
Thank you.
Representative Johnson? Representative Johnson?
Chair Fraser, Mr. Schwab, I want to thank you for being here today. You've always been very open and willing to provide information to this, to all the members that when we ask. You talked about the workforce issue, and unfortunately, that's an issue across the entire economic area of the state. There's people that, I know people that in my area that they've been looking for employees, especially in some of the skilled areas, for decades, and they cannot find them. One thing, it's easier to compare between the executive branch and the judicial branch, the salaries, stuff like that, but it's a little more difficult to go to the private sector because of pension issues and other compensation that's offered, so. But I also want to thank you for I believe it was last biennium, when you came in here not knowing how things were going, and you just wanted to do the 1 year of the salary increases, and you were looking forthright and not knowing where things were going to go, and I want to appreciate that. It's unfortunate that things fell apart last year, so we couldn't take care of the second half of the request. I also want to thank you for all the work you have done to try to get the case backlog taken care of. But I'm also wondering if you could provide the committee with county-by-county stats on the case law and either county by county, or if it'd be easier by district. But I would like to see the whole county by county, so we can also go in and compare where huge dramatic spikes in crime that might have also instigated some of that backlog.
Mr. Schwarber?
Chair Fraser, Representative Johnson, we certainly have that data county by county, and we can provide that detail to the committee.
I appreciate,
Representative Johnson?
Chair Fraser, Mr. Sharper, I appreciate that. I had one other thing I was going to ask about, but I forgot what that was now. So
That's
I
okay.
just
I'm
wanna
sure you can-
Thank you. Oh, I remember now.
Go ahead, Representative Johnson.
On the remote hearings, I believe that can be used in a lot of different things, but there's some things that when it comes time, we do need to be in person. As a former law enforcement officer, I've done interviews over the phone. I've even in the last few years when this committee has been in Zoom, it's not the same. As a law enforcement officer, and I'm sure some judges and other people in the courtroom know, it's not just the words that people say, it's their body language. And by video and remote, you do not get that body language. The other thing is, when some people are doing their confessions or pleading guilty or stuff, you don't know what's on the other side of that camera. Are they being forced to do it? That's why some of these things need to be in person. I think we need to take a real close look at what we're doing remote, and when we actually have the hearings, to make sure that things are being done properly. So, thank you.
Mr. Schwarber, if you can quickly, then we got a few more people we're going to push on. Go
Chair
ahead.
Frazier, Representative Johnson, I couldn't agree with you more. The council, this is a iterative process. The council is doing a very strong evaluation of how things are going. We've already made some changes, especially in the juvenile delinquency area, where exactly for your point, some of these things probably should be in person rather than remote. There is an exception process where a judge can create an exception to the framework if necessary. So we are continuing to evaluate it, and we'll be happy once the evaluation is complete to come back and tell you how it's been. So thank you.
Thank you, Mr. Schwarber. Members, I'm going to ask if we can be brief when we do ask a question. I know Mr. Schwarber does have to get out of here. So Representative Friedrichs.
Thank you, Mr. Chair. Thank you, Mr. Shorba, for the presentation. When you were talking about the different services that the courts are providing, it reminded me of some emails and conversations that I've had with people after they serve jury duty. And so I'm curious in what the courts are doing to support people who have served jury duty, and if that jury duty was incredibly traumatic. Some of the stories that they shared were sleepless nights from like reliving the trauma that they heard about in the courtroom. And so my question, to be brief then, would be how are the courts supporting jurors after traumatic trials?
Chair Frazier.
Mr. Schwarber.
Frederick. We do have some services that we can refer jurors to in terms of services that they can get, sort of like we have with employees with our employee assistance program, similar to that. And they can decide whether to take them up on them. Those are not provided, those are provided free of charge to them. So we do have some ways that, especially in these very traumatic situations where they're viewing evidence that's really difficult or hearing testimony or children involved. So we do refer them to those services. Thank you.
Thank you. Rep. Weens.
Mr. Chair, Mr. Schwarber, thank you for your presentation today. I'm really convinced that there's a lot of good work that you're doing here, especially with the veterans courts, and that's near and dear to my heart. But they're not all the same. There's a wide variety. Just maybe briefly, if you can explain if there's a different tiered group of counties that report, and then maybe a future office visit where I could discuss how we can move forward and maybe come to a more unified process with the Veterans Court process. Thank you.
Mr. Schwarber.
Chair Fraser, Representative Weens, Chief and I will be coming to see you, and happy to talk in more detail about veterans courts. We have a process that the Judicial Council approves courts that must follow a uniform framework for providing services to match what are the national best practices. Once you've gone through that process, you have to follow that. I will say that in certain counties, they've chosen not to go through that. So, for example, Washington County is one of them, where they've done their own thing. And I would much rather have them all be uniform, but I only have so much power. But anything we can do to encourage them to go through the process so we have more uniformity would be excellent.
Thank you.
Thank you. Representative Carroll.
Thank you, Chair, and thank you for being here. So let me just follow up on a couple of the questions that some of the other members have asked. And I was a longtime Hennepin County attorney, conducted thousands of hearings, and you mentioned the use of remote technology. I've taken part in some of those. I found them clunky, but that was a bit ago. I'm sure the technology's improved. But are there some types of hearings that you're anticipating would lend themselves better to use of remote technology versus in person?
Representative
Chair
Mr.
Fraser,
Schwarber.
Representative Carroll, The general framework is that anything that involves providing evidentiary information should be in person. So if it's some kind of a status hearing or something that is not going to providing either probably testimony, but more importantly, any kind of physical evidence that is presented, those should be in person. I will say that the exception process I've mentioned, most of the exceptions have been by litigants who've wanted to go remote when it's presumptively in person versus the other. So we're learning. I can't agree with you more. When we all ran back to our basements and got our computers going, things were very clunky. I think we've gotten much better at how we're handling them, and we're only improving, but your observation is very true.
All right, thank you.
Thank you, Mr. Schwarber. Representative Niska.
Thank you, Mr. Chair, and thank you, Mr. Shorba. I appreciate it. I just wanted to very briefly comment about the salary issues. You know, the folks we're talking about, judges and court staff, in the grand scheme of things, are not poorly compensated. But I think that it's very important for all of us to remember how important well-functioning judicial system is to everything that we care about. And I think quality does matter. The folks that we're talking about for judges, we're trying to recruit them in a competitive marketplace where almost every judge in the Minnesota state courts, I'm sure, could find a better paying job somewhere else, and they're doing it to serve the public and to serve our judicial system. And so not to prejudge necessarily the number that you're asking for, but I think it's important that we all really take seriously the importance to our legal system of making sure that we are having the highest quality judges and judicial staff. Judges do a lot of work themselves, I know. I've been a law clerk and I've been in front of judges. So they are part of the staff that's really doing important work, but the law clerks and the other judicial staff also, it's important that we have high quality people there. So just wanted to comment on that. Thank you.
Thank you, Representative Niska. I'm going to close out here. Just one point and a couple quick questions. One point, our public servants are very important, and we should compensate them accordingly to make sure we have the best and the brightest. And then the other piece is I do want to make sure that we also focus on, I mean, it is an entire system. So our public defenders, our prosecutors, we'll be hearing from them also. Want to make sure that we're compensating them when we talk about the backlog specifically. They play a part in making sure we get that backlog down. One question, how many, you talked about our judges and staying competitive. Are we seeing an issue or a trend where we're losing judges right now based on the competitiveness of our salaries? Mr. Schwarber?
Chair Frazier, we have seen in the last year a couple judges leaving for higher paying jobs. Generally in the past, it's very rare to see a judge leave public service until their mandatory retirement, around 70. So we are seeing a little bit of a trend in that area. It's mostly on the number of applicants side, but we're starting to see some of that as well.
Is that when you said a couple, is it literally two?
I think it's 2 or 3.
2 or 3?
Yeah.
Thank you. And I don't know if I got a number. I know Representative Moller asked a question about salaries. What is the current minimum salary for a judicial officer, judge?
So the district court judge salary is $169,264. Court of Appeals judges are at $180, and associate justice on the Supreme Court at $191.
Thank you for sharing that, Mr. Schwarber. And thank you for your presentation.
Thank you. Thank you, members.
Members, we do have 4 bills on the agenda, so we will be moving a little bit more briskly now. And we have House File 305 coming up right now. Chair Becker-Finn.
All right, I will move House File 305 be referred to the Committee on Ways and Means.
Chair Becker-Finn, your bill is before the committee. Please proceed.
Yeah, so House File 305, so for members who've been on this committee in the past, this is the bill this year that we're moving forward to get rid of that statutory fee on copies of court documents. We had a lot of support for this over the last year or two. Would have become law had we had a bill last year. And that's why we're sending it to Ways and Means. We're hoping maybe we can take care of this early. So essentially, currently in statute, it's required that there is a fee charged for documents. And we all know now, as more things are digital, charging $8 to email you a PDF or to download a PDF, that just doesn't make sense. These are public documents, and the meaning of them being public, if nobody can actually access them without access to cash, just kind of goes against what we're trying to accomplish and making sure our justice system is open, and that people have trust in the system. They need to be able to access those documents. So that is the bill. We do have a couple testifiers, and I do want to make sure we have time for those. But yeah, it's a pretty straightforward bill. It's just getting rid of that fee.
Thank you, Chair Becker-Finn. We have first up Ms. Sarah Bush. Please have a seat, introduce yourself, and proceed.
Good morning, Chair Frazier and members of the committee. My name is Sarah Bush, pronoun she, her. I am the Community Engagement and Outreach Manager at Missions, Inc. programs. We provide shelter and supportive services to victims of domestic violence and individuals experiencing problematic substance use in Northwest Hennepin County. I'm here today in support of House File 305. Our legal advocates serve approximately 600 victims of domestic violence through civil and criminal court processes each year. A fee associated with downloading or viewing court documents online would represent a huge financial burden for our program and others like it across the state. On a typical day, our legal advocates download at least 10 court documents that allow them to reach out to victims for input on cases, prepare for court hearings, and create safety plans with victims. That's the bare minimum of how many court documents they need to access. But paying $8 per document for even that minimum number would cost our program $20,800 a year. That's about 6% of our entire program budget. More importantly, having free access to court documents has a significant impact on the people we serve. Here are a few examples. A victim receives a call from one of our legal advocates the morning after they were assaulted by their intimate partner. Because the legal advocate was able to access the criminal complaint online, the victim doesn't have to relive the traumatic experience by relaying the details of the incident. Instead, their conversation with the advocate can focus on the victim's immediate safety needs. One of our advocates receives a call from a client panicking because their child's other parent is refusing to return their child in accordance with a very specific custody arrangement. Our advocate is able to access the official custody decision online, email it to the victim, and the client can show law enforcement the exact details of their custody order regarding exchanges. Finding new housing is one of the many ways in which victims seek safety. Recently, an advocate helped a victim access all of the eviction documentation she needed to begin working on expunging her record, as having a past eviction on her record was preventing her from accessing safe housing away from the person causing her harm. In conclusion, our program could not afford to pay for every court document we need to access. Without free access to digital court documents, advocates, who are largely funded by state and local government grants, will be forced to travel to courthouses every time they need to access court documents, wasting time and taxpayer dollars. This would be particularly cumbersome for rural programs. Without free access, victims and advocates will lack key information when creating safety plans, court proceedings will be less accessible to victims, and victims who are criminalized or facing eviction will encounter even greater barriers to accessing safety. We therefore urge you to support House File 305. Thank you for your time and the opportunity to testify. I'm happy to take any questions.
Thank you, Ms. Bush.
Thank you.
Next up, we have Matt Eiling, and then in the on deck after that is Rich Newmeister.
Thank you, Mr. Chairman. My name is Matt Ealing, here on behalf of the Minnesota Coalition on Government Information. For those who are not familiar with us, we're a nonpartisan, nonprofit organization whose all-volunteer board of directors advocates for public record access and public access to government information, and we educate the citizenry on open records issues. So our board supports this bill. We thank Chair Becker-Finn and her co-authors for bringing it forward. You'll see several written submissions from members of the legal community, members of the press who are in support of this bill. And to those voices, we want to add the voices of the citizens of Minnesota. This is an important access issue for everyday citizens in this state. I just want to add a little bit of historical context to this. As we've described to this committee before, Minnesota has a very robust open records tradition in regard to government information. And part of that tradition hinges on this body's determinations about what is public, what's not public, but also part of the policy considerations hinge on threshold questions of access, mechanical and procedural questions about how do you get access to government information, including questions of cost. And historically, if you look at the Data Practices Act, which is the mechanism through which city and county and state records are available to the public, the legislature very wisely decided many decades ago to put an option in that act to make information available for free. If you couldn't afford to get costs, you can go and see the records and inspect them for free. There's a similar provision in the court records rules for inspection. This also adds to that free inspection tradition, free copies of court records now. And this is important for because there's a liberty interest often in court proceedings. If you are proceeding on your own in court without the assistance of an attorney, you need access to all of the court filings. And so not having a barrier of cost there to get access to those filings, we feel is a very important procedural matter. So again, we support the bill. I'm happy to take any questions, and we look forward to seeing this proceed through the legislature. Thank you.
Thank you, Mr. Island, and sorry for the mispronunciation. Mr. Neumeister, please come down. Please introduce yourself for the record and proceed.
Mr. Chair, members of the committee, my name is Rich Neumeister. I applaud, finally. This has been a discussion for many years, and it's a kumbaya, as I've seen in committees. There are some things that everybody can agree on, just like I think there will be another bill that everyone will agree on later on. I'll just give you the visual concept. I've lived across the 2nd Judicial District City Hall here in St. Paul for nearly 40 years. I go into that building quite often, just like I come to the Capitol. And I go downstairs to where court documents. And I still remember when you couldn't take a picture of a document. And the reporters called me, and there was an effort then, all of a sudden you can take pictures and save the $8. And there were people, like so described, you regular, everyday people you represent. This bill will solve that deal. There are people that go up to the 18th floor in the Ramsey County Courthouse who are trying to find out things so they can do things for themselves. And a long period of time, the law libraries, I'm sorry, but we can't give you free copies. You got to go and all that. And this will help many people. I thank you. Hats off to you all.
Thank you, Mr. Neumeister. Any public testimony? Chair Becker-Finn.
Thank you. And I will say too, I mean, I maybe one of my law clerk jobs, I maybe would not have had that job, but I was always sent to the basement in the Hennepin County Government Center to go get the copies of things because they weren't readily accessible. But obviously that's not an efficient use of resources, and we want to make that better.
Thank you, Chair Becker-Finn. Any public testimony before we move on to member discussion? Seeing none. Representative Niska.
Thank you, Mr. Chair. I'll be very brief. Thank you, Representative Becker-Finn, for bringing this bill forward. I just want to make sure everyone understands if you look at this particular bill, only signers are of one party, but I want to make sure everyone understands that this is a very bipartisan issue. I hope it's a non-controversial issue. It's a very similar bill. It's a little differently worded, but I think has the same intent that was introduced by Representative Robbins, that I and Representative Scott are both co-authors on. That's House File 138. So this is an important thing. It had, like, as Representative Becker-Finn, as you mentioned before, there was bipartisan support for this last legislative session, and I think there will be again. And I just wanted to echo the important values that this does support. Obviously, as we heard, it's important for government transparency, but I also want to speak to the rule of law value of this bill. We talk about being a society that's governed by the rule of law and not of people. And, you know, that means a couple different things. It means that we're all equal under the law, and that no one's above the law or no one is below the protection of the law. But it also, I think, means, and historically has meant, that we as the people who are governed by the law should have the ability to the best extent possible to know what the law is that we have to live under. And I think that doesn't just mean being able to access the words of the statutes in a book or on a website. It also means being able to understand the ways that that law is actually being applied in actual cases. And so to the extent that the courts have done a good job of making these documents available, including court orders, online, and they've created a pretty easily accessible website that does it, and to now be able to make that free, I think, serves that important value as well. And so I'm happy that this is moving forward, and thank you for that, and I'm happy to support it. Thank you.
Chair Becker-Finn, I don't know if you want to comment at all.
No, we can keep
All
the
right.
discussion going. I got other stuff we got to get
Thank
to
you, Chair
today,
Becker-Finn.
but there is room to sign on,
All right.
Representative.
Representative Scott.
Thank you, Mr. Chair, and Chair Becker-Finn. This is a good bill. I see my name is not on it, so I will be adding it later today. But it's a good bill, vote yes.
How about that for bipartisan? I don't see any other further discussion from members. Chair Becker-Finn, would you like to close out?
Just to summarize, I really think this is an equity issue. There are currently ways that, like, sometimes attorneys can have access to things, and we should all be able to access the same public documents in the same way. Just really appreciate the bipartisan support on this.
Thank you. Chair Becker-Finn renews the motion to re-refer House File 305 to the Committee on Ways and Means. All those in favor say aye.
Aye.
Any opposed? Motion prevails. Chair Becker-Finn, you're staying right there. Next up is House File 1580.
Yep, I would move House File 1580 brought before the committee, and just so members know, my intention is to lay this bill over. Still getting some clarity on exactly what the number needs to be to get this right, so we'll be laying this over, but did want to get this before the committee at this time. So I would move House File 1580, and then we'll also move the DE1 amendment. Just some drafting errors, and wanted to clarify some things. Some questions came up after it was introduced. So same intent, just clarifying some things. So would also move the DE1 amendment.
Members, any discussion on the DE1? All those in favor, say aye.
Aye.
Any opposed? D1 is now before us. Chair Becker-Finn.
Thank you, Chair Frazier. And this bill is specifically about pay for district court law clerks, for our law clerks, as was talked about in the previous discussion, and why we wanted to make sure we had plenty of time to get the courts up here to talk about those things earlier this morning. Just specifically want to call out our law clerks as we talk about civil legal aid attorneys, as we talk about public defenders and all the other players in the system. Our law clerks are not, we don't often hear their voices, but they are an integral part of our justice system. I'm a former law clerk myself. I actually had the privilege to work under Justice McKeag when she was just Judge McKeag in Hennepin County. So really important thing. I know many of us who are attorneys have worked as clerks and understand how important they are. And with that, I want to make sure we have plenty of time for our presenters today.
See, we do have a number of testifiers. Judge Lois Conroy, please introduce yourself for the record and proceed.
All right. Well, may it please the chair and members of the committee, my name is Lois Conroy. I'm a district court judge in the 4th Judicial District and president of the Minnesota District Judges Association. I want to thank the law clerks who are here, or former law clerks that are here today on the committee. It's a pleasure to have so much support amongst you on the committee. I come here today representing more than 300 judges across the state of Minnesota. And we are here to say how vital and essential our law clerks are to the work of the judicial branch. We have several legislative priorities for this session. You've already heard from Mr. Shorba on number 2. I'm just going to focus today on number 1. I want to extend my gratitude to Representative Becker-Finn for authoring this bill, and to Representative Moller, Representative Frazier, and Representative Feist for co-authoring. Thank you so much for your leadership. I want to first talk about the indispensable nature of the work that our law clerks do. When we served district court judges across this state, what we heard from them is that law clerks are essential and very important to performing the duties as a judge. This stands to reason when judges don't just call balls and strikes in our courtroom, but we must put down on paper in written orders well thought out reasoning and well articulated basis for our decisions. Minnesotans expect that we not only provide those well-reasoned decisions, but they frankly deserve that these decisions are received in a timely manner. You already heard from Jeff Shorba talk about the delay of 8 weeks in getting final orders out in dissolution cases. You're going to hear today from 3 clerks, a current clerk, 2 former clerks. They're going to talk a little bit more in detail about the work that they do, the complexity of that, the volume, and the inadequacy of the pay. But I want to turn to pay. $57,000 a year. This is astonishing. Our law clerks have 4 years of an undergraduate degree, 3 years of law school. Many have passed the bar or soon pass the bar after coming to work in our chambers. $57,000. We know something is radically wrong when a judge in northwestern Minnesota this last year lost their law clerk to the Senex station. We know something is radically wrong in Lyon County when a judge went 6 months without a law clerk. This is for a job that is essential to the daily functioning of the court. The effects of this low pay has meant that 93% of Minnesota judges across this state has seen a decline in qualified applicants for law clerks. Let me just give you an illustration. 5 years ago, when I was looking at law clerk resumes, it took me hours to go through all the applications that came into Hennepin County. If I was looking at law clerk applications just 4 weeks ago in January, it would have taken me 10 minutes. There was only 1 application in Hennepin County for our open pool law clerk position. That's not even talking about quality, that's just number. We have reached a tipping point in which we can no longer fill these positions, and it stands to reason. When we look at law clerk pay, it is far below the market. So how did we get here in this decision making? The Minnesota District Judges Association recognized and heard from this committee last year how important the issue of law clerk pay was. Immediately after session, we created a law clerk committee of judges across this state, and we went to investigate, to gather more information about how pervasive this problem was and what were possible solutions to fix it. Our law clerk committee has been led by the experienced leadership of Judge James Moore from the 4th Judicial District, who is present here in our hearing this morning. With his leadership, that committee went around the state to hear from judges. They wrote a survey to gather how important this issue was and how big the problem is. Those survey responses were astonishing. Maybe even use the word staggering. In 1 week of this survey being out for judges and clerks to respond, we had more than 500 responses. When you think about there being 300 judges and a little over 300 law clerks, a 509 rate of response, is extremely high. We had touched a nerve within the judicial branch. From those results, what we learned is that 3/4 of judges have had to hire a law clerk in the past 2 years. More than 2/3 were having difficulty hiring or retaining qualified law clerks. And 2/3 of judges were without a full complement of law clerks. They went without a law clerk between 1 and 3 months. That's 2/3 of judges. There is no denying that we need to close this gap between what district court clerks are paid. We need to move them to the level of the sophistication of their work. What we know is that other public law attorneys make approximately $16,000 more than our law clerks make. Same level experience, immediately graduating from law school, but yet paid significantly less. We have listened carefully to the members that we represent, those judges. We have listened carefully to our law clerks, and we have listened carefully to the input that we've received here at the legislature and from your staff. And we have aggressively gone out to seek information, seek hard data, and seek solutions. Unfortunately, as you know, this takes time. We had the results of that survey come in December of 2022. That's far after our Judicial Council budget is created and submitted. And so the timing means that we, in fact, are coming here today for a request that isn't noted in our judicial branch budget. But I think you already heard loud and clear from Judge Shorba. We have a staffing hiring problem and a staffing retention problem. And this is just to put a finer point on what those are. I want to state that the urgency of this problem has never been more dire than it is today. That you have received letters of support for this bill, House File 1580. And in those letters of support, I wanted to highlight the support that comes from the Minnesota Asian Pacific Americans Bar Association. Their president, Christopher Gissen, stated the following in his support of this bill. This low starting salary disparately impacts students and attorneys of color, many of whom come from historically lesser means and would have difficulty working as judicial law clerks. The presence of diverse talent in the judicial branch is critical, as the lack of it can negatively impact the administration of justice and the public trust in the legal system. Chair and members of the committee, the Minnesota Judicial Branch has an obligation to the citizens of Minnesota to deliver justice. How much justice can we deliver when we cannot attract or retain qualified clerks? How much justice is there without law clerks to assist judges in delivering timely and well-reasoned orders? And how much justice is there when we do not pay our clerks a competitive wage? The good citizens in this great state expect and rightly deserve a quality judicial branch. This cannot be done without the indispensable work of law clerks. I want to be mindful of your time. Chair and members of the committee, thank you so much for the privilege of testifying before you all here this morning, and I'd be happy to take any questions. Also, I will note that we have 3 clerks who are here to testify as well.
Thank you, Judge Conroy. I appreciate all that you do and everything you just presented. Thank you. First up is Ellen Tashida.
we could add judicial branch to that little sign.
Mr. Sheeta, please introduce yourself for the record and proceed.
Good morning. My name is Ellen Cheetah. I am a law clerk in the 4th Judicial District, Hennepin County. I've been a law clerk for a long time, since 2005, and I've worked in many divisions of the court. I feel safe in saying that the law clerks throughout the state feel undercompensated for the work that we do, regardless of working in the Twin Cities or in Greater Minnesota. As salaried employees, there's no overtime, though the workload often requires more than 8 hours a day, and many of us work on weekends to get the jobs done on a timely basis. This position is often viewed as temporary, but there are lots of us who have worked many years as a clerk. In Hennepin County, because we do many administrative tasks, the learning curve is steep, and it often takes more than 1 year to even learn all of our duties. And yet the experienced clerks are not often compensated for their level of knowledge and efficiency. For instance, my duties include research and writing initial draft of judicial orders, preparing for motions, hearings, trials. We also clerk the trials, of assisting the jury, keeping track of exhibits, preparing jury instructions, and drafting any post-trial motions. In addition, law clerks in the Hennepin County Civil Division are in charge of the judge's schedule. All civil hearings, formal and informal, are set by us. We review any new case filings on a daily basis to see if there's any immediate action necessary. We issue scheduling orders and keep track of the status of all the cases. In my office, there are 2 of us handling anywhere between 130 and 170 civil cases at a time. We update the hearings in Mensis. We keep track of the due dates and anything else that needs the judge's attention after the hearing. All of our court cases are subject to certain mandatory timelines and statewide timeliness guidelines set by the judicial system itself. We also handle criminal matters. Pleas by mail are converted to orders for conviction and sentence, which is helping with the criminal backlog that we've had. We handle continuances and modifications to sentences. And as you have heard, this workload has increased since the pandemic. We are in charge of Zoom hearings, making sure we have court reporter coverage and being in the office. This often means we are the only one who has to come into the office on any given day. We answer all calls to the judge from lawyers and self-represented litigants and often have to explain some of the processes while not giving legal advice. This alone can be very stressful, and running the chambers and managing the administrative tasks has reduced the time we have during the workday to do the original job of the law clerk, assisting the judge in the legal decision-making. My experience is far from universal in Minnesota. Duties of the law clerks vary significantly depending on the judicial district in which we work, and differ even between the different divisions of one judicial district. But I know I speak for many around the state when I say that the salaries we receive are not commensurate with our education, our experience, and our role in the judicial system. Given the cost of living, many of clerks have said they could not even have a decent place to live without a secondary source of income, and those with families are struggling. Not to mention the resumption of making student loan payments, which will now be resuming shortly, which is often higher than that of other employees. As you have heard from Judge Conroy and others, we've had difficulty in hiring and retaining law clerks who are willing to do what is required of the job. Pay increase would assist in maintaining quality employees who are essential to the system. Thank you very much.
Thank you, Ms. Sheeta. Up next is Nicholas Ridman. Mr. Ridman, please introduce yourself for the record and proceed.
Thank you, Chair Frazier, members of the committee. My name is Nick Redmond. I am here not to speak on behalf of a client, but on my own behalf as a former law clerk, judicial law clerk in the 4th District, Hennepin County. And I'm going to try to be brief and give you just sort of my own personal experience. I came to law school with 0 undergrad debt. I left law school with a scholarship for half tuition with more than $200,000 in debt. When I went to the 4th District, I wanted to do so in order to learn how the sausage got made. I wanted to see what happens, how the judicial system works, so that I could be a better attorney. My clerkship did teach me the ins and outs of the judicial system. I was there from 2019 until the end of 2021. In that time, I moved with my partner to a 2-bedroom condo in Minneapolis. That was $19.50 a month. My pay was $54,000 a year, and so I made about $1,400 a paycheck. So roughly half of my income was going towards rent each month. My job was with the then civil presiding judge for the civil division of the largest district in the state. So not only did I do all of the tasks that Ellen referred to, but I also had additional somewhat tedious tasks that I had to perform for the civil division. And months into my tenure as a clerk, the pandemic struck. And like everyone else, we had to adapt to that. But unlike a lot of other folks, the judicial clerks were expected to essentially craft and implement policies to allow the system to work during the pandemic. We were the only ones often who were allowed into the building. On many days, my job was to drive to the Hennepin County Government Center, pay for parking because parking was not free. Often that would be about $20. So an hour of my day's wage was parking because I wasn't going to take the light rail and subject myself to whatever COVID was happening in the light rail. And my job then was, essentially the reason I had to go in on those days was to press a button in order to turn on the court reporter software that had to be physically turned on. My job otherwise could have been done mostly remotely at that time. But I essentially took a pay doc in order to perform my essential duties. I also had to do this with the utmost professionalism because I represented not only my judge and my chambers, but also the judicial branch as a whole. And our task was to ensure that the public trusted the judicial branch to make the right decisions. The logistics of all of that work included everything under the sun. We wrote every order, at least the first draft of every order. I had one order that substantially unchanged from my judge went up to the Supreme Court. And I believe that judicial law clerks not only are running around behind the scenes getting things done, but they also are in some cases influencing law and making law because they are lawyers writing opinions, and appellate courts are taking those opinions and basing their decisions off of those. I often would refer to my judicial clerkship as a legal residency, and I do believe that it is a valuable job for attorneys. I think that the bar in the state of Minnesota is well served by having as many of the brightest attorneys possible becoming judicial law clerks, because one-on-one mentorship with a judge, my chambers was me, my judge, and my co-clerk. That mentorship time, I think, made me a better attorney. It led to my ability to go into private practice, which was not for me. And now I am back in public service, but
Mr. Ribbon, I am going to add, we have one more
Yes.
testifier, so if you want to wrap up a
yes,
bit.
just very briefly,
Yeah.
in terms of pay, my salary tripled going into private practice. That allowed me to buy a house, consider and become engaged. And even now, back in public service, my salary is roughly double what it was as a judicial law clerk.
Thank you. Thank you, Mr. Rittman. Mr. Abu Amara.
You might have to time him, Mr. Chair.
I will be brief.
We got to understand him. Let's go.
Good morning, Mr. Chair, members. Abu Amara, former clerk on the Minnesota Supreme Court, an attorney at Gustafson Glick. I'm going to be brief. 3 points. First is, without law clerks, the Minnesota Judicial Branch does not work. Just flat out, it does not work. The integral nature of the district clerks, and I'm here as an appellate clerk, and I'm here because I think the importance of helping to build the record at the district court level is so essential. As someone who has seen appeals, if you don't have folks on the ground making sure that, testimony is taken and recorded and evidence is established, it's going to mess the case up as it goes up on appeal. So that's the first point. The second point is, this is the future of Minnesota's judiciary. Judges don't just pop out of thin air. These law clerks are the future judges in Minnesota. And so if you don't invest in them now, you won't see them on the back end because they would have experienced a whole different trajectory. And this is their first opportunity to get public service. And that's an important thing that plants a seed for them later in their life. And then the last piece is, I just think it's important that we pay people what they're worth. And so many times we think because you're young, we can not pay you as much. You're not entitled to as much. You'll make that money later. These are talented, experienced, thoughtful people who have advanced degrees, and they should be compensated for that. So if there are any questions, I'll take those. But with that, I'll just stop.
Thank you, Mr. Mayor. We're gonna hold. Oh, I'm sorry.
Mr. Chair, thank you.
Scott, go
I
ahead.
just wanted to say, Mr. Amar, you left out the most important qualification that you had, and as a staffer here at the House of Representatives, so.
Thank you, Lee Scott, for catching that. We are gonna hold discussion, and this bill will be back. We're gonna lay it over. Chair Becker-Finn, do you have any comments before I lay it over?
No, just I thought it was really important that we hear from the clerks. We don't often hear from them, and just appreciate them all being here to testify today.
Okay. With that said, I will move to lay over House File 1580 as amended. I will pass the gavel back to our esteemed chair.
Representative Moller?
Representative Moller, up next.
I feel like I need some music. Representative Moller, go ahead and move your bill.
Thank you, Madam Chair. And just to clarify, I believe the motion is to move this to the general register. All right, great, thank you. And I don't have an amendment. Members, some of you will remember this bill from last year. And this came about as a result of some of the carjackings we were seeing in the Twin Cities. And I had a conversation with the Ramsey County Sheriff and said, to try to understand what was going on and what tools they needed. And they said that one of the tools they needed was the ability to be able to use, they have technology now to use these GPS trackers on cars that are stolen. And one of the reasons why is in order to prevent some of the high-speed chases that we're seeing. If law enforcement can attach one of these trackers on a car that's stolen, it means they can follow the car until it's safe to be able to stop the car and apprehend the suspects without putting the public at risk, the people in the car that's stolen at risk, and law enforcement at risk. So that's what this bill does. And Madam Chair, I have one testifier.
All right. Under Sheriff Martin, come on up. Please introduce yourself for the record and then proceed with your testimony.
I'm Under Sheriff Mike Martin from the Ramsey County Sheriff's Office. Thank you for having me today. I'm the commander of the Regional Services Bureau within the Sheriff's Office, which among other things includes our carjacking and auto theft team. In 2021, in the spring of 2021, we saw a dramatic increase in the number of carjackings and auto thefts, and as a result, we created a carjacking and auto theft team just to proactively identify the people who were the most prolific car thieves and to try to reduce those carjackings and auto thefts. And I should say that we are appreciative of the Minnesota Department of Commerce for helping fund several of our investigators, 3 of our investigators that do this work in Ramsey County. One of the things that we noticed is that we were seeing an increase in people fleeing from us when we went to stop them. And we wanted to reduce the amount of risky pursuits that we had, and we looked for technology that was available. There were multiple technologies available to help us track cars so we wouldn't have to engage in a high-speed pursuit with them. And we went out and purchased those devices, but we quickly learned, which we should have figured out beforehand, that actually the statutes prevent us from placing a GPS device on a car unless we have the consent of the owner, the registered owner of the vehicle, which is fine, but a lot of times we can't get a hold of the registered owner, even if they've reported their car stolen. They're at work, they're out of town, they don't have the ability to get a hold of them. So what we're asking for is the ability to place these GPS devices on cars to track that vehicle if it's been reported as a stolen vehicle, and then remove it as soon as we recover that vehicle. If we can't locate the vehicle within 24 hours, then we would seek a search warrant that would allow us to continue to locate the vehicle. This is something that we brought up last year. Representative Moller introduced a bill, and in the process of that, we spoke to Rich Neumeister, spoke to the ACLU about some of the concerns they had, and addressed those in an amended bill this year.
All right.
Thank you.
Thank you for your testimony. We do have one member of the public signed up to testify, Mr. Neumeister. If you could keep it short so we can get to our full agenda today.
Madam Chair, members of the committee, my name is Rich Neumeister. 3 short points. This bill is a work product of many voices that balances rights, liberties, and privacy with needs of law enforcement with the new technology. I thank you, Representative Moller and Senator Mark Johnson, who in the other body, for working out this language. Number 2 is I have a concern about, again, a caveat, as I shared in the last committee, is that, okay, after 24 hours, there's a search warrant, but how many times does that happen? Somehow, as I said then, I'd like to see some type of reporting put in an incident report, arrest report, or something like that. And down the line, again, it's a very short item. It's a very easy fixable thing. The third point, and the important point that Representative Moller knows, because as I bird dogged this bill throughout both bodies, I'm sure she heard from the other side and here too. The statutes of 626A has not been touched in 35 years. I worked on the section that was involved. Technology has changed. Court cases have changed. So when judges, the public, and even law enforcement read these statutes, they do actions based on what they see. Technology, as we know, has changed, and we also know, everybody in the legislature knows, that law enforcement likes nice toys of technology, and we don't hear about it. When I say we, you as policymakers, and we the public, unless you do a data request, which I've done sometimes, and then come to you to get laws to do that. So if there is anyone here.
And right now, Mr. Neumeister, this bill is the one before us. We're not going to speak to what they want or what they think, but we've got to get moving.
But if anyone wants to work to update the statute, 626A, it'd be some good work, and I'm sure, Madam Chair.
Send an email, Mr. Neumeister. All right. Anyone else from the public wishing to testify on this bill? All right. Member discussion. Representative Finke.
Thank you, Chair Becker-Finn. I know we're pressed for time. This is the first time I'm hearing this bill. Obviously, it's been before this committee before, and
Also through public safety.
public safety.
Yep.
So, I have never heard it before. It strikes me as quite concerning, but I'm not going to ask all my questions right now. I just feel like I would like to know more about what's to keep an officer from tracking a vehicle that may or may not be stolen for 24 hours, and how do we know that we're not going to just be tracking people, because tracking devices are very concerning to me. But I know that we're pressed for time. We don't have to go into the whole backstory.
Yep, and Representative Moller, I think, can answer this.
I can, and these are exactly the concerns the ACLU had when the bill was first drafted, and that we narrowly crafted the amendment that's part of this bill. Now, it only applies to stolen cars. My understanding that the database the police have for a car that's reported stolen is very good, so that they know that a car is actually stolen. So just to be clear, it's only going to apply to stolen cars. There isn't a Fourth Amendment concern with that, because you have to have a reasonable expectation of privacy for the Fourth Amendment to apply. And I would say that somebody who has stolen a car, that expectation of privacy isn't there. Also, these are exigent circumstances, so another exception to the Fourth Amendment. And so we also put in the 24 hours. This isn't for police to use this as a tool to find out, is this person who stole the car going to this house and this person and that person? This is so that they can safely stop the car when they have the right number of resources, apprehend the suspect without doing the high-speed chase, and remove the tracker. So that's why that 24-hour rule is there.
All right, quick follow-up, Representative Finke.
I had a high-speed pursuit end in a crash very close to my home. I totally understand the need that is serving. I just want to make sure that we're not allowing cops to track people because they have the tools to track people.
Representative Scott.
Thank you, Mr. Chair and Representative Moller. I had some of the same concerns, Representative Finke, and Representative Moller's worked on this bill with advocates such as the ACLU because there is such a concern about that. And I feel comfortable with what this bill is doing. It's very narrowly crafted. Law enforcement has a database. Only stolen vehicles are, it only applies to vehicles that have been reported stolen. And it's kind of remarkable technology, as we all know. It's like, I equate it to you when people go trap shooting, and it's like flinging this little disc, and then it attaches to the car.
I equate it to Batman.
Okay, or Spider-Man or something, I don't know, but it's really interesting technology. But I do agree with Mr. Neumeister that there probably should be a reporting mechanism in here so that we know how often it's being used, how many times the search warrant is being asked for, if the 24 hours is not adequate. And I'm sure maybe Representative Moller could even attest to this, or the sheriff. Percentage-wise, roughly, how many vehicles are recovered in that first 24 hours that are stolen? Thank you.
Under Sheriff Martin. If you don't know the answer, I'm sure we can find out later.
Chair Becker-Finn and Representative Scott, I would just off the top of my head estimate that 80 to 90% are recovered within the first 24 hours. If we're able to deploy a device on that vehicle, I would say that would be 99% of vehicles. We have had individuals, when we had permission of the owner and we've placed these devices, we've had criminals find the device and remove it from the car because they knew we did something. They just didn't know what it was.
All right.
So,
Thank you.
Yeah, thank you. Closing comments, Representative Moller.
Thanks for the opportunity to present again, and appreciate your support.
All right. Representative Moller renews the motion to recommend that House File 686 be placed on the general register. All those in favor, please say aye.
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 Opposed? The motion prevails, and the bill is on its way to the general register. Still going to try not to keep us over time by very much. Representative Pinto, I will move your bill, House File 93, be re-referred to the Rules Committee. We're looking at constitutional amendments. We send those to Rules, which is a little different than where we send most bills. So House File 93 is now before us. Representative Pinto, to your bill.
Thank you, Madam Chair. And I know time is tight, and members, it's you can see the bill in front of you. It's quite simple. There's language in our state constitution that although it prohibits slavery, does provide this exception that you can see in case of punishment for a crime. Many states have eliminated this from their own constitutions, including Alabama, Tennessee, a number of others. That was just in November of 2022. This is something that we should be doing. I've got, I know at least one testifier here, I believe possibly two, and so we'll just have them come up.
All right. Todd Axtell. Former chief. Please introduce yourself for the record and then proceed with your testimony.
Thank you all very much, Madam Chair and members. It's really an honor to be here with you today. This started for me as a bit of professional reading. I'm sorry I didn't introduce myself. Todd Axtell, retired chief, president and CEO of the Axtell Group. So this started New Year's Eve of 2019. I created a resolution I put out on social media where I challenged all of us to take our 162-year-old document and update it with one update that really bothered me as I read it and understood that slavery is still allowed in the state of Minnesota under the current terms if it's a punishment of a crime. And as I asked our officers when I was the chief of police in St. Paul to raise their right hand and swear to uphold the state and the United States Constitution, it's an outdated, unnecessary, offensive term that we still have in the state of Minnesota. And I really believed at the time, and I still believe today, 165 years later now, that this wording in our Constitution needs to be updated to reflect the values of our state, to reflect the values of the criminal justice system, and to make sure that it's a just document for all members of the state of Minnesota. It's a non-controversial thing, I believe. Last year, we had 4 states that adopted this. There are 20 states left in the country that still allow this wording in their constitution. The only state that shot it down last year was Alabama, and I don't want to follow the lead of Alabama. I think that this is time for Minnesota to move forward and strike this archaic language from our Constitution. So thank you very much for the honor of being here today.
Yep, thank you for your testimony. I have Tamara Hill on the list. Please introduce yourself and proceed with your testimony. Welcome to the committee.
Thank you, Madam Chair, committee members. My name is Tamara Hill. I'm a registered lobbyist and a policy officer at the Center for Victims of Torture, which is a nonprofit headquartered in St. Paul. I'm here to testify in support of House File 93. Founded in 1985, the Center for Victims of Torture, or CVT, is a nonprofit organization. We're headquartered in Minnesota, and we have operations in the U.S., Africa, and the Middle East. We extend rehabilitative care to survivors of torture and other forms of cruel, inhumane, or degrading treatment or punishment. We build the capacity of colleague torture rehabilitation programs and human rights defenders worldwide, and we engage in advocacy aimed at ending torture and cruel, inhumane, and degrading treatment and supporting the rehabilitation of survivors. I run our Healing, Incarceration, and Policing program, which is a program that advocates for legislation that uplifts and supports our clients and communities in Minnesota while increasing equity and accountability in our public safety infrastructure. With our long history of advocating for the basic and most fundamental rights of people, CVT supports this bill and urges the committee to pass this important legislation. It is long past time for our state to take a stand against this law that is a remnant of chattel slavery. Involuntary servitude or slavery remains illegal in our state and country unless a person is incarcerated for a crime. However, we're a different state than we were in 1857 when the Constitution of the state of Minnesota was adopted. As a whole, we should be able to accept that indentured servitude or involuntary slavery in any and all cases is unconscionable, and that those who are incarcerated are still people with basic rights. Their humanity should be respected as such. When a person is sentenced to imprisonment, that imprisonment is the punishment. Cruel, inhumane, and degrading treatment is not included in their sentence. Coercive, degrading, dangerous, and abusive labor practices undermine our democracy and our criminal legal system. In addition, they prevent the rehabilitation of people who are incarcerated. As such, this constitutional amendment is vital to the betterment of public safety in the long term and will benefit the lives of many in the short term. Our legislature has the opportunity to be a leader on this issue in the country, and it's something that we should really take advantage of doing. It is past time, it can be done, and it's imperative to maintain the integrity of our state's values and establishes the expectation or standard for fair and humane treatment in our prisons. Thank you all so much for your time.
Thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, we'll move on to member discussion. All right, closing comments, Representative Pinto.
Thank you so much, Madam Chair and members. I think there may have been a misstatement earlier saying that Alabama voted this down. Alabama actually did pass it. I think it was Louisiana that voted it down, but so our state should join Alabama and others.
Yeah, if we're going to feel bad about some other state, we got to be clear what that other state is.
I absolutely
So
should not
thank you.
besmirch the name of Alabama.
There we go.
So thank you, Madam Chair.
All right, with that, seeing no further discussion, I'll renew my motion to re-refer House File 93 to the Rules and Legislative Administration Committee. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. The bill is on its way, and thank you, members. Only 5 minutes over. With that, we are adjourned.